Hi, everyone. Welcome to the fourth episode of Fenwick's COVID-19 public company webinar series. My name is Ron Bensour. I'm a capital markets and public companies partner at Fenwick. I'm joined by an all-star cast of associates to talk today about annual meetings. We've got Julia Forbes to my right on the Zoom screen and Jen Hitchcock to my left. They are both senior associates in our capital markets and public companies group. We thought that this was a very good topic to discuss in light of the fact that many of our companies are coming up on the April end deadline for filing their proxy statements for purposes of incorporating Part 3 information into their 10Ks. And we've got many companies that are thinking about what to do with their annual meetings in light of the current COVID-19 pandemic, whether to switch from physical meetings, which most of our clients have done historically, to virtual meetings, disclosure issues associated around that, how to deal with stockholders, and some of the guidance that we've seen from some of the proxy advisory firms. We've actually, and Julia kind of led the effort on our client alerts around this topic. So why don't I kick it over to Julia to maybe lead off the discussion.
Thanks a lot, Ron. So as Ron mentioned, for many of our clients who have a December 31st year end, their proxy is with Part 3 information would normally be due on April 29th this year. So this is very relevant timing here. The SEC has announced that they are extending all deadlines that are hitting before, I believe, July 1st this year, 45 days. And so to the extent there is Part 3 information that is not able to be incorporated, companies are scrambling, they've been hit by a COVID outbreak, some extenuating circumstance, we'd just like to point out that you do have the ability to take an additional 45 days to file your proxy and incorporate Part 3 information there. However, we do think that it's unlikely that many companies will need to avail themselves of this, particularly because the Part 3 information is historical in nature, and unlike the financial information in the 10K or the 10Q, it will not require an auditor consent and is less subject to real-time sort of significant impacts. So the SEC also has just announced recently that if there are other delays in the proxy process related to printing or the physical delivery of materials, they're relaxing their standards around delivery of proxy materials as well. So if you as a company were planning on doing a full set mailing and mailing out the proxy and proxy card to all of your stockholders, but would like to switch to notice only delivery because of timing considerations or issues with printing with whoever you're using for printing process, you may do so without meeting all of the requirements of Rule 14A16. I think the most significant relaxation there would be the SEC has indicated that you would not have to send out your notice and access cards a full 40 days prior to the meeting. Usually that's a longer poll in that tent to getting your materials out to stockholders. However, you must make sure that you're making a good faith effort to get your materials out and give stockholders an opportunity to access the proxy materials still in advance with enough time that they can look over the materials and vote in an informed manner. So sending them out, probably even a week before your meeting is still not going to be sufficient. So you need to spend some time thinking if you're going to make that switch, when and how to best do it. If you do decide to make that change, and you have a request from a stockholder for paper copies of the annual report or of the proxy, you should also remember that you should still send them that proxy, the paper copy, even if it's going to be a little bit late. And then once these timing considerations and those logistics are resolved, there's another consideration that companies face around how are they holding their annual meetings. Most companies do tend to hold a physical meeting. Investor advisory firms such as ISS or Glass Lewis have traditionally taken points off if you don't hold an in-person meeting. They feel like the physical meeting gives stockholders a better opportunity to engage with the company and ask questions, and they are concerned about stockholder participation in a virtual meeting setting and view them as non-investor friendly. So that's been the way.
I think, by the way, in terms of what we've seen on the virtual meeting front, is sometimes our clients have struggled with those meetings, in the sense that oftentimes you actually do have more participation in a virtual meeting than you do in a physical meeting. For many of our clients, you might have one or two stockholders show up to the physical meeting. Virtual meetings oftentimes, in my experience, actually encourage more stockholders. The virtual meetings are actually very challenging, in the sense that, and I know Jen and I have had this experience before, where you do get a lot of additional questions during the virtual meetings, and sometimes those are questions from smaller stockholders. Many of the times those questions are, I would kind of characterize them as sort of inappropriate for purposes of an annual meeting setting. But you do want to be very thoughtful about, if you do decide to switch to a virtual meeting, how you address or think about addressing questions that you get from stockholders in that setting that you probably otherwise wouldn't have gotten in a physical meeting.
Yeah, Ron, I think that's a really important point. So one thing that we've been kind of encouraging clients to do who are switching to virtual meetings is to think about doing some dry runs, and then also to prepare like Q&A of questions that they think that they'll likely get asked, just so that they have kind of thoughtful responses, and then to also kind of talk through, the kinds of questions that are and aren't appropriate with outside counsel, just so that they are prepared, because oftentimes you do get a slew of questions that aren't necessarily appropriate to address at the meeting, and just being ready to kind of figure that out live can be a little challenging if it's the first time.
Yeah, that's a great point. And also you need to think through your procedural scripts and how you're handling questions or other disruptions in the meeting. That's a very good point.
So Julia, if you do decide to go virtual, what are some of the things that we advise companies to do from a disclosure perspective? I know some of the proxy advisors put out some guidance on that both last year and this year.
Yeah, and so this year they're making an exception for COVID-related public health considerations. And so Glass Lewis has sort of led the charge on this, but ISS is following suit. And indicating that they're not going to score companies lower if they choose to hold a virtual meeting this year. And they specifically cite in their proxy that the reason that they're doing so is for public health reasons or other sort of governmental limitations reasons. So we definitely want companies to mention the fact that they are making these health considerations as they change their meeting schedule. Normally, if you are choosing to hold a virtual meeting, and what Glass Lewis and ISS would expect in the future, would it be a more robust disclosure? So this year they're not requiring all of the disclosure that they normally would, although, to the extent you have time and want to lay it out, normally the kinds of things that they would want you to address would be how stockholders can ask questions during the meeting, including any sort of time guidelines that might be put on stockholder questions, or rules about the questions that are allowed. So all this back-end planning that you and Jen just discussed a moment ago should be outlined in the actual proxy disclosure. And the procedures for posting the questions should be made clear, and also posted on the company website after the meeting is adjourned, so that everyone has access to those.
By the way, that's actually, and we actually started putting that disclosure in last year in response to these new proxy advisory guidelines, and that's pretty simple disclosure to put in. So I would definitely recommend for clients to put that language in, and we're certainly ready and willing to help craft that.
Julia, one thing that I thought was interesting that you'd kind of alerted me to was that, for folks switching to virtual meetings, that they should really get in contact with their proxy advisor firm kind of as soon as possible, because it looks like there are certain days and times that are really popular, and that these proxy advisor firms might actually run out of bandwidth on certain dates.
Yeah, that's exactly right. We're encouraging people to make a decision or at least alert their proxy services advisors if they want to do a virtual meeting sort of ASAP. You can get into their schedule. They can do the background build. You know, you can still have the optionality of holding the physical meeting if you want to, but you're in their list. It's there's probably some cost involved, but it's a reduced cost just to kind of get the placeholder, get the build going. This is not something that they can do overnight because of the sort of technical limitations and technical requirements of being able to have this, you know, have stockholders join and ask and answer questions. And sort of on that note, companies should be thinking about whether they want to try to have a physical meeting at this point or just switch fully over to the virtual meeting. To the extent companies are sort of focused on trying to have a physical meeting if at all possible, particularly if your meeting's in June, you know, who knows what the state of the world could be then. So maybe you filed your proxy already and you indicated a physical meeting. There's some certain steps that you should take if you're going to change over to a virtual meeting after you filed your proxy statement. And I think Jen is going to run us through some of those steps for changing from a physical meeting to a virtual meeting.
Yeah, absolutely. So maybe just starting with, if you haven't filed your proxy, but you do plan on holding a physical meeting, you know, we do encourage, and I think Julia and Ron, you've already kind of alluded to this, that you build in optionality kind of in case, you know, due to travel or health restrictions. And there are numerous examples of disclosure and proxy statements along those lines, but they generally state that it's possible that the location may change, including to a virtual location. And if that happens, that the company will notify stockholders through any number of means, including a press release, an SEC filing, or the company's proxy website. And then if you have kind of built in that optionality by the time that you file your proxy statement and the location does change, we do still recommend filing the notice of change as additional soliciting material in EDGAR. And if you've already made clear in the original stockholder notice that this was a possibility that, that there would be a switch in the location from physical to virtual, then there is no need to do a new stockholder mailing under the SEC or Delaware rules and regulations. But then Julia, as you're kind of noting, kind of if you've already filed your proxy statement indicating that you plan to hold a physical meeting, you know, you're not out of luck, but you do need to consider certain SEC rules, state corporate law, and the company's charter documents. The SEC has actually issued guidance around this in light of COVID, indicating that a company can change the date, time, or location of the meeting as long as it takes 3 steps. So the first step is that you have to issue a press release announcing the change. You need to file the announcement as additional soliciting material on EDGAR. And then you need to take all other reasonable steps necessary to kind of inform the other intermediaries of the change. And then actually just in the past few days, Delaware announced that it would also be relaxing its stockholder notice requirements to kind of match the SEC guidance that we just outlined. So it eliminates the need for any additional notice under Delaware law. But we would flag that other states may have corporate laws that still require a stockholder mailing to provide proper notice of the meeting change. So in that situation, we would encourage you to kind of talk to your lawyer about any special process around that. And then you should also confirm any other limitations in your charter documents if you are planning on moving the time or location of the meeting. So kind of just in summary, and then I'll turn it back over to Ron, there certainly is more flexibility this year around proxy statements and the annual meeting process in light of COVID, but it does remain an area where there is a lot of technical adherence to procedure. So we definitely encourage you to start evaluating your options for holding a virtual meeting if possible, and then absolutely encourage you to reach out to one of us if you have any questions about the information discussed on today's webinar or about process in general.
So Jen, I think you stole my thunder around the summary. So I think we can probably call it an episode, and look forward to seeing everyone on the next one. Thank you.
All right, thanks all.
Guys.